Well, I do believe I am live now. So, welcome everyone. Thank you very much for joining me. For those joining me for the first time, who am I? Well, my name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We have the largest employment practice in Canada. We operate in Ontario, in BC, and in Alberta. And the reason I am here has everything to do with employment law. I'm here to answer your questions about your job, your compensation, your severance, if you're being mistreated at the workplace, if your job has changed, if your boss gave you an ultimatum, if you're not sure if what your company is doing is legal, whatever the issue is, if it has to do with work and your job, this is the time to ask the question. I'm live, you're watching me right now. So just type in the question, hit enter. I'll see it, I'll answer it, and you can walk away with that information. Questions are already coming in. I'm going to get to all of them. Please ask your question now. Don't wait till the end of the session because you may run out of time or I may run out of time and then you won't have your questions answered. So again, those joining us, thank you guys, first of all, for joining. I do enjoy doing this every week. It's a privilege to be able to communicate and answer questions. But let me give you some other information. To reach me, again, I'm Lior Samfiru. All you do, if you want to connect with me off air, very simple. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. Now, when you go to employmentlawyer.ca, you can learn and read a lot more about employment law and educate yourself that way. But when you go to employmentlawyer.ca, you can also get all the contact information from me and my whole team, phone number, email address. So after the session, if you want to have a private chat or a private email exchange, you want to tell me more about your situation, you want me to roll up my sleeves and get to work to help you, very easy to do. Just go to employmentlawyer.ca. So that's the place to go. But right now, over the next 30 minutes, I am here live for your benefit at your service, answering your questions about employment law, telling you what you need to know, solving those workplace problems. So again, I'm Lior Samfiru. Let's get to it. But in the meantime, ask your question. So let's see. The first question we have is from N. Stinson on YouTube. Promoted to new role 2 years ago, same pay, department and manager as before. Does the employer have the legal right to move me back to the previous role? Is that a constructive dismissal? We did not sign a new employment agreement. So because the change is not a significant change. So if you were let me give you this way. If you were promoted, your employer can't demote you. Okay. But if it's kind of the same role that they moved you into, they could probably put you back in the old role unless there's a good reason why you couldn't do it. If it's embarrassing or it means working hours of work that you don't want to work. But if it's pretty much the same, just different responsibilities, they can do that. For it to be a constructive dismissal, it would have to be a significant change, where there would have to be a really good reason as to why you can't do it or it's embarrassing. If it's just, hey, I prefer this job than that one, that's probably not enough for it to be a constructive dismissal. So based on what you're telling me, given the fact that the two jobs have the same pay, same department, same manager, it's probably not going to be a constructive dismissal. But I could be convinced otherwise if you tell me the main reason as to why you wouldn't want to go back to the other job. So hopefully that makes sense. If you want to follow up, you have time, so please do that. Everyone out there, you see how easy it is? You ask the question, you get the answer, and now you know. I'm going to continue answering questions, but ask yours. Don't wait. Next question comes from Alan on Facebook. I've been doing more than 3 years of a full-time job. I don't have an employment contract, and I was on sick leave. When I came back to work, they put me to work only 1 or 2 days a week. So I worked for a few months and had a difficult financial situation since I was employed by full-time, and they unfairly cut it off me. Am I entitled to financial compensation? I quit at the end of 2021. So here's the issue here. If you were able to work full-time and they told you can't do that, we're going to only have you work part-time, that's illegal. That's a constructive dismissal. And even though you quit, you're entitled to severance. But here's the problem. What you didn't tell me is how long did you continue working part-time? Because if you worked more than maybe a couple of months, then you might not be able to do anything about it because that could be acceptance of the part-time job. Now, if while you were working, you were trying to convince them to move you back to full-time, you were discussing this with them, you may still be fine even if you work there for longer. So bottom line is, yes, this can absolutely be a constructive dismissal. In fact, it could also be a human rights violation. It's illegal. All right. They can't just decide because you were sick to reduce your hours. So you may want to, well, not may, you really do want to connect with me, Alan, off air. Okay. To do that, Alan, all you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen below me. And once you go there, you'll have my phone number and email address. But Alan, I don't want you to walk away from this, okay? We need to talk. You may have some very significant entitlements. Hopefully that makes sense, Alan. Employmentlawyer.ca. See again how easy it is. My name is Lior Samfiru. I'm the employment lawyer, and I'm here again at your service answering questions about employment law. And I'm here to help and make sure you get to the answers that you want. Now, Alan, you say you worked there for 3 months. Yeah, let's talk. Yeah, you may still have the ability to claim. So let's connect as soon as possible through employmentlawyer.ca. All right, I'm going to continue answering questions right now. Ask, type it in. Answer will come from me as soon as possible, so take advantage of that. Okay, so N. Stinson has a follow-up. She says, very different job duties than previous role, which was much more stressful. I never want to go back to that role. Going back to the old role may require me to return to the office. There you go. That's the thing. You work remotely now. So if in fact you now have to go back into the office, they cannot do that. So if you have a job right now that's remote, everything's fine, but they want to put you in a different job that would require you to go back to the office, yeah, that would absolutely be a constructive dismissal, not even a question. So I'm not convinced that the job itself, if you can continue doing it remotely, it would be a constructive dismissal. But if they say, well, you're going to go into a different job in the office instead of 100% remote, that is a constructive dismissal. You cannot, they cannot do that. So now you know. And if your employer does that, as soon as you hear that that's what they want to do, you call me. Okay, not a week later, not a day later. Call me right away. Again, employmentlawyer.ca to get all that information. All right. Next question comes to us from Deborah on Facebook. I'm a nurse that was terminated for not taking the mandatory vaccine. They said I was in frustration of contract. I argued, and months later, I got a check for severance. Didn't sign papers. My union signed on my behalf. I was there 15 years. Unfortunately, Deborah, because you're part of a union, the union is the only one that can help you. The union is the only one that's allowed to do anything on your behalf. So whether what the union did is right or wrong, at the end of the day, I can't do anything about it. You can't do anything about it. When you're part of a union, the union has the rights, not the employee. The union has the rights and the ability to enforce rights. So if your union says that's it, there's nothing else that we're going to do, there's not much that you can do about it. Okay, so it would be a very different situation if you were not a union employee. You'd probably be looking at over a year's pay. But in a union environment, if the union is not going to do anything, there's no option. And I want to make it very clear for everyone watching. Everything that I talk about on this session, everything that you may hear me talk about on TV or on radio, only applies to non-union employees. It does not apply to unionized employees for the same reasons I just gave Deborah, that if you're unionized employees, the law kind of takes a backseat and the union has rights and the ability to enforce them. I can't help you. You can't do something yourself. It has to be the union. So if you're part of a union, nothing of what I'm about to say or what I say on these sessions is going to apply to you. It does not apply to you if you're part of a union. All right. I think I'm caught up here on the question. So waiting for some more questions here. Ask them. Make sure you get those answers before we're done today. As I'm waiting for the next questions, let me tell you about another tool that you absolutely have to know about. Absolutely have to know about. And that is our severance calculator. Over 2 million people have used it across Canada. That's how useful it is. That's how easy it is to use. So what does the severance calculator do? Well, as the name says, it calculates and tells you how much severance you are owed. It's as simple as that. You can find it, by the way, you see that address below me at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. When you go to the pocketemploymentlawyer.ca website, you'll see the severance calculator. You click on it, and you'll be able to find out in seconds how much you're owed. You answer 3 questions, and it tells you whether you're owed 6 months severance, 10 months, 24 months, or anything else in between. It's free. It's anonymous. It's easy to use. You don't have to put in your name, company's name. You can get the answer, turn it off, and you're done if that's what you want. And if you want also, you can connect with me and contact me directly from the calculator if you want it only. Now, why do you care? Why should you care about the severance calculator? Is that a lot of people believe, well, I'm owed 2 weeks severance or a week per year. Wrong. False. You're owed much, much more than that. Don't believe me? Check out the severance calculator. Make sure you find out what you're really owed, the full amount. We call this also your common law amount, common law rights. So check it out, pocketemploymentlawyer.ca. Always the first place you go to if you lost your job, are worried about losing your job, or are just interested in knowing how much severance is actually owed to you. All right, I'm Lior Samfiru, the employment lawyer, right here live answering your employment law questions. Continuing right now to answer questions. Type them in, guys. Don't be hesitating. All right, Janice on Facebook has the next question. I just won a WSBC for workplace bullying and harassment. I hired a lawyer to appeal, even though I am in a union. My union didn't assist me with when WSBC denied my claim, but I sent it back for further investigation. So I'm not sure what the question is there. A union can only deal with your employer. They can't deal with a government agency, etc. So a union can only deal with your employer. So your employer has obligations to you if you're a victim of harassment. But the only one that can help you get those entitlements is your union. Okay. Next question comes to us from Francis on YouTube. Recently terminated for cause because I canceled changes made by my estranged spouse's account. Cancellation was because, amongst other things, I felt involved my private life. Okay, so I'm not sure exactly what you mean by you canceled changes. Changes to what? I'm not sure exactly. What I will say, Francis, is that it's extremely difficult to terminate an employee for cause. Very difficult. You would have had them to do something terrible, something awful. The fact that maybe you did something wrong, I'm not saying you did, but even if you did do something wrong, that in and of itself is very likely not enough to be cause, which means unless you did something terrible, your employer's, from a legal standpoint, that termination of your employer is considered a without cause termination, meaning, of course, you get your full severance. That's the difference between a for cause and a without cause termination. Severance. For cause, no severance. Without cause, full severance. So unless you did something terrible, they owe you your full severance. And I don't know, depending how long you've worked there, that could be as much as 24 months pay. So let's see. So you say that your estranged spouse was part of management and friends based with key actors. I have no idea what you're saying there. Sorry. But here's the thing. Again, unless you did something terrible, you're owed severance. That could be as much as 24 months pay. So you want to connect with me off air as soon as possible. I would not wait on this. Okay, to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen below. Phone number is there, email address there, and I can get to work to help you make sure you get what you're owed. Okay. Next question is from the Hebrew Hammer. If a company doesn't offer proper severance package, this is considered a wrongful dismissal. Yes, exactly. And you say, should I be getting a higher severance package because of the wrongful dismissal, or is this a completely separate issue? No, I think you're misunderstanding. The lack of severance is the wrongful dismissal. So you don't get more, you get what you're owed. So if a company, let's say a company owes you 10 months severance and they pay you less than that, they pay you 5, you've been wrongfully dismissed, meaning they have to pay you 10 months. If they had paid you 10, it wouldn't be a wrongful dismissal, it would be a legal dismissal, and you wouldn't be owed anything. But in most cases, in 90% of cases, when someone is let go, they've been wrongfully dismissed because their employer pays them or offers them less severance than what they're actually owed. Okay, so most people, the vast majority of people, almost everyone, frankly, when they're let go, they're staring at that severance letter, they've been wrongfully dismissed. The good news is it's not difficult to resolve it. As soon as a company sees my firm's name on the letterhead, they go, crap, because they know we've called them on it. They know we know what we're doing, and they agree to pay. We resolve it quickly, and you can get your legal payment and move on. That's why it's so important. If you lost your job, even if you think your severance offer is fair, even if you think that what the company offered you is legal, call me, or just go to pocketemploymentlawyer.ca, use the calculator, because chances are, despite you thinking that it's okay, chances are that it's not. And I'm not talking about the fact that, well, they offered you 5 months and it should have been 6 months. I'm talking about in many cases, most cases, they offered you 5 and it should have been 10 or 15. So that's why it's so important to connect with me, Francis, and anyone else if you lost your job. Or sorry, I meant Hebrew Hammer. All right, let's see, and just make sure I'm not missing here. Okay, Deborah has the next question. Okay, no, she does not. Mike or Milka, sorry, has the next question on Facebook. Sorry for mispronouncing. I was laid off October 29th of last year. How long can I wait before I take action, and what are my options? Worked December 2016 to October 2021, laid off for non-accepting the vaccine. Well, you can treat your termination now as, you can treat your layoff now as being a termination. So you could have done that on day one back in October of last year. You didn't have to wait. So you have two options. Option number one is you wait and see what the company does. How long will you wait? I have no idea. It may be a long while. That's option number one. Option number two is you can choose to consider that layoff as a termination of employment and get your severance and move on. If that's what you decide to do, which I think makes sense, call me or email, and we'll get to work to help you. To do that, Milka, you can go to employmentlawyer.ca. As I said, the phone number is there, the email address there. We have forms there that you can fill out if you prefer. It's all there for you to connect with me and my team across Ontario, across BC, and across Alberta. So hopefully that answers the question. If not, please, you have time, ask a follow-up question. So these are some of the issues that I deal with all the time: losing your job, having your job changed, vaccine issues. So whatever the issue, whatever the problem, you see how easy it is to get answers. You all have a right to know about your workplace, right? To get answers. So if you've always wondered something, you have an opportunity right now to ask that question. So as I'm waiting for next questions here, and again, don't hesitate. I wanted to talk about certain things that if they happen in your workplace, you have to be mindful of. Before I do that, a question just came in from Stephanie on Facebook. I was just told not to go back to camp with no reason for weeks now, no correspondence, nothing. I need a callback ASAP in BC. I also will contact Human Rights Tribunal. Well, I'm not sure exactly what it has to do with the Human Rights Tribunal. It has to do with the fact that if they stop giving you work, that's a termination. So call us, okay? Easy to do that, and we'll help you get compensation, get severance, or if you really want to go back to work, we can potentially help that happen as well. It's not a human rights issue unless you think that they stop giving you work because your age, your ethnicity, your disability, unless you think it's discriminatory like that. But if it's simply a matter of they're being jerks, they're not calling you back, or they're not giving you work, well, then it's not a human rights issue. It's a wrongful dismissal. So to connect with me, Stephanie, easy to do, as I said, employmentlawyer.ca. Again, employmentlawyer.ca. For those joining us right now, my name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP, operating in Ontario, BC, and Alberta, and I'm here live answering your questions, so ask them. Still have about 10 minutes to go, so you have plenty of time to get your question in. Continuing to answer your questions, Curtis has the next question. Did you already discuss the recent vaccine case, Parma, that declining the vaccine is effectively a resignation? If not, I would like to hear your thoughts. So this is a case out of BC. My firm has been hired to appeal that decision. We're appealing that decision. I expect we'll be successful in appealing it. It's wrongly decided. I am not relying on that. I'm not putting any stock in that case. There's various reasons which I'm not going to get into as to why we disagree with that case. So from my perspective, everything you've heard me say about vaccinations and or not vaccinations, about the rights of employees as regards to vaccination still stand. Okay. We're appealing. My firm has been hired to appeal. We didn't do the trial case. We're appealing it, and I expect that this case is going to go away. All right. Next question is from Julia. My sister was recently placed on an unpaid leave after reporting a supervisor for harassment. It doesn't look like they are doing anything about it, though. What can she do? It's improper completely to be put on an unpaid leave. Completely. Now, in some situations, maybe the employer can say, we'll put you on a paid leave while we investigate because we don't want you to be in the workplace in an uncomfortable situation. But to put someone on an unpaid leave is a disciplinary thing. So they're disciplining someone that's complaining about harassment. That's illegal. Right there, we may have a breach of employment standards, a breach. It could be a wrongful dismissal. It could be a breach of occupational health and safety, potentially even a human rights violation, depending on the type of harassment. It's illegal. So what you have to tell your sister ASAP is to call us. There's a few things that we can do for your sister. Either we can get her out of there with compensation, or we can make the company take her back and give her back pay for the time she's been put on an unpaid leave. Either way, we can help her. So, Julia, you have to have your sister contact us right away. To do that, for her to contact us, employmentlawyer.ca. Just give her that address, employmentlawyer.ca. She'll have a phone number there, email address you can use. You can fill out a form. Let us help her. Okay, there's nothing I can do to help her over social media. I need to speak to her, need to get involved to help her. Thanks for that, Julia. Take the next step and have her reach out. All right, continuing to answer questions. What I love to do. You guys have a few more minutes. Get those questions in. Next question from Mary Beth on YouTube. Hope you don't charge high fees. People lost jobs, no incoming income. So let me talk a bit about that. The vast majority of our consultations are free. They can't all be free. And in some situations, depending on the matter, we may have to charge an initial consultation fee. Most of our consultations are free, and that's assessed when you call us. We'll be able to tell you, yes, we can proceed with free or not. Most are free. The cases that we actually take on, the vast majority of those, we offer contingency. So we don't charge anything. We proceed, and we only bill if we're successful and there's money coming from the other side. So never hesitate to reach out to us. You'll know what your options are. If we can't offer you a paid consultation, we'll tell you. Most people do get paid consultations. Certainly, if you lost your job, in those cases, almost always it's going to be a free consultation. Almost always. In some cases, if we can't, we'll let you know. All right. Next question comes from Rocket on YouTube. Should I work for a company with a unionized position that pays more money or a non-union that pays less money and less benefits? I have no idea. That's up to you. Next question comes from N. Stinson. The employer has so far provided 2 negative performance reviews. Okay. First one 10 years ago, second one 4 years ago. In both cases, I did not agree with what they wrote, and I said so in writing. Excellent. Okay, can they rely on those 2 prior reviews and lay me off for poor performance again in the future? So what they can't do is they can't fire you for cause. They can let you go. Well, you're federally regulated, you say. So no, a federally regulated employee cannot be let go unless there's cause, unless the position just doesn't exist anymore. So can they let you go because of poor performance? No, they won't be able to let you go in that situation. And if they do, you could not only get severance, you could potentially get reinstated with back pay. All right. So no, they can't do that. If anything happens, call, okay? Or just go to employmentlawyer.ca. Nancy on Facebook just submitted her question. I'm waiting for a new job offer. First one was not close to what my job was as a resident live-in manager. I'm waiting for a second offer. If it's not close, do I have to accept? What are my options? So I'm not sure exactly what you mean. Are you already working there and they're giving you a different job, or did you apply for a job? So I need to have more information, Nancy, to be able to give you a meaningful answer here. Either type in the other information or just connect with me in the office, employmentlawyer.ca, and I'll be able to help you. All right, guys, last 5 minutes. You still have a bit of time to get your questions under the wire, so don't hesitate. If you've been kind of sitting there wondering, should you ask, should you not ask, ask. Okay, I'm Lior Samfiru, the employment lawyer, answering your questions live. Next question on Facebook from Rita. I received a written warning on my file because out of frustration about a chair being put in my area where I work. I removed the chair from my office aggressively and it hit a door. They didn't explain why it was being put in the office. So it doesn't seem like a big deal, and having that warning is not going to matter too much. It's not going to impact your job. But here's what I would do to be safe. I would send an email saying, here's what happened, just so that you know, this happened, it bothered me, it's not something that I usually do, and I wasn't being unreasonable. So just kind of put your position as to what happened in writing. You don't need them to respond to it, but just by putting that in writing, it's going to make it that much more difficult for them to hold that against you in the future. But either way, I wouldn't worry about it too much. It's not something that's going to impact you. They're not going to be able to use that to fire you for cause. So I wouldn't lose any sleep over that. Okay, Nancy has the follow-up there that says, Nancy was talking about the fact that she was offered a new employment agreement. They let go of my property manager. The new property manager took over, so it would be getting hired by them. So I need to see it. So this is important because in some situations, if you don't accept it, that may be considered a resignation. I need to actually see the offer. I don't want to give you advice here, not having seen the document, and tell you don't worry about it, because then you may actually be considered to have resigned. So what I want you to do is I want you to send me I want you to connect with me, first of all, off air. I want you to send me the agreement. I want to read it. I want to discuss it with you. And then we'll have our strategy as to what to do and what your rights are. But this is too important for me to just give you answers right now, not having seen that document, okay? So Nancy, I want you to connect with me through employmentlawyer.ca. So Nancy says, is there a 3 strikes rule? There isn't such a rule, okay? It doesn't exist. It has to do with what you did, how many times you did it, how serious it was, and how long ago it was. So I'll give you an example. If you did 2 things 10 years ago, forget it. It doesn't matter. No one cares. It's not going to impact you in any way. If you did 2 things last week, yeah, it may matter. But it also depends on what you did. So if you were late twice by 5 minutes, no one's going to ever be able to use that to terminate you for cause. On the other hand, if you had 2 instances where you didn't show up for work for no reason, and then that may be more serious. But no, there's no 3-strike rule. It doesn't exist. It really does depend on the context, what you did, when you did it, and how often. I think I'm caught up on the questions now, as I usually am on time here. So this is great. Always tremendous questions. You guys ask the best questions, but we can continue the conversation. We can have follow-up discussions. I can give you more information and even get to work to help you. All you have to do is connect with me through employmentlawyer.ca. Again, employmentlawyer.ca is the place to connect with me and my team across Ontario, BC, and Alberta. I'll be back next week. I always am back. But hey, don't wait a week if you have more questions. Ask those today. Again, employmentlawyer.ca. Don't forget about our severance calculator, pocketemploymentlawyer.ca. You can use that now. You can turn off your screen, grab your smartphone, and use our severance calculator to find out what you are actually owed. Before you even use it, have a number in your head. I bet you'll be surprised when you see the real number, what that real number should be. Guys, thank you for joining me. I'm Lior Samfiru, the employment lawyer. Always a pleasure to be here and answering your questions. Thank you for joining me today. We'll talk again soon. All the best.